Hey, good morning, everybody. Welcome back to Law and Legitimacy, where once again, Mike and I struggle with the wider world, and I, in particular, struggle with the technology that keeps me attached to it. No guarantees that my microphone will work throughout our broadcast entirely this morning, but I did play with it some this weekend, so let's stay tuned. If it fails, Mike will just keep talking and say, that's on brand for us, because I'm a 30-something and I'm up to everything technologically. The dinosaur over there in Connecticut, aka Norm, can't seem to find his digital pants with both hands. Well, maybe that's true.
More on brand than talking about the thing that you don't think is on brand.
Anyhow, yeah, that's true. Hi, welcome back to Law and Legitimacy, where every irrelevant topic is made relevant, at least for the half an hour you share with us each morning. So let's start with something pretty significant. I don't know how many of you had an opportunity to spend a little bit of time with Judge Sarah B. Wallace's 103-page order, but I'm guessing not enough. I did read through it. Let me tell you what I see in it. The question of whether Donald Trump is eligible to get on a state ballot in his run for presidency in 2024 will have to be resolved by the United States Supreme Court, because there is confusion in the state courts about what to do with Section 3 of the 14th Amendment. And Exhibit A of that confusion is this order, is Sarah Wallace's order. Well, just by way of review for those of you who are new to the topic, Section 3 of the 14th Amendment disqualifies a person from serving in a federal office if they'd previously sworn an oath of loyalty to the United States and then engaged in insurrection or offered aid and support to insurrectionists. And so a very influential law review article came out earlier this year saying that, well, you know, what this means then is state officers, state electoral officers, state secretaries of state, for example, state town clerks, they have an independent constitutional responsibility and duty to keep an unqualified candidate off the ballots. And Donald Trump would be one of those unqualified candidates because they claim he engaged in insurrection or aided and comforted those who engaged in insurrection on January 6, 2021. So people have begun to raise claims in various courts around the country, usually citizens and or citizens groups, in efforts to keep Donald Trump off the ballot. Thus, we see in Colorado, Norma Anderson, Michelle Priola, Claudine Camarda, Krista Kafer, Kathy Wright. They sound, I hear, you get a holiday party invitation from those five, run. They sound real charming. And then Christopher Castilian. I guess they had to find a guy in there, either that or he's a woman identifying as a guy to make it a gender mixed group. But in any case, they raise a claim. They want to keep the Secretary of State, Jenna Griswold, from putting Trump on the ballot because Trump, Orange Man bad, Trump engaged in insurrection, therefore he's disqualified from serving. There were a series, and Trump intervenes, the Colorado Republican State Central Committee intervenes. There is heavy motion practice, that is efforts to get the case thrown out and to narrow its scope in September and October of this year. Those motions are resolved and the case goes to trial, and Judge Wallace heard 5 days of evidence and then last week came out with her ruling. And and I won't bury the lead. The bottom line is the Secretary of State in Colorado has been ordered to place Trump on the ballot. In other words, Judge Wallace reached the conclusion that Section 3 of the 14th Amendment does not apply to Donald Trump. But what a tortured piece of reasoning this decision is. I don't know if judges are elected in Colorado. Mike, you're shaking your head no.
I was agreeing with you that it was a torture to read that decision.
So, but she reasons as follows. So, both parties presented evidence. Among the evidence brought by the petitioners, that is, those seeking to keep Trump off the ballot, was an expert in social science who contended that Donald Trump spoke in coded language that extremists understood. And that when he used the metaphor of fight, we need to fight for our country, that wasn't just political speech, that wasn't just motivational speech, that was coded language to people who understood it to mean fight means engage in violence. And as circumstantial proof, the expert testified that any number of times in rallies, Mr. Trump praised those who used violence. We should punch a person who throws a tomato. You know, you should have hit him harder. These things were coded cues that primed his audience to understood.
Norm, quick aside, if I may, because I did find something here.
Yeah.
Colorado apparently is sort of a hybrid model. So all the judges in Colorado are appointed for an initial term. And then what I have on the screen is how long the term is, and then how they are retained by voters after they're appointed. So I don't know much.
Yeah, I mean,
much about Judge Sarah B. Wallace, but at least that answers the question for purposes of this discussion.
She gave a little bit of something to everybody. So she permitted the expert to testify, which in and of itself, in my view, was a questionable move, and a somewhat frightening move. It's sort of the same move that we see present in a lot of the internet cases, the so-called stochastic terrorism cases, that if a person engages in speech, hateful speech online, others will take that speech and act on it to the detriment of the public or particular members within the public. And thus we saw in the Alex Jones case, for example, a former student of Islamic terrorism testifying about Jones's internet reach and the impact that that would have on his audience. In any case, in Sarah Wallace's case, she permitted the expert to testify that Trump's speech was violent and understood to be violent, and that as a result, he engaged. Oh, stop that, Dawn! As a result, he engaged in insurrectionary behavior. In other words, he inspired people to act violently against the enforcement of the Constitution. And he did so, she concluded, with specific intent. And she engaged in an analysis of the lead court decision on violent speech, on the so-called Brandenburg decision. This is a case involving incitement, and Brandenburg and its progeny, in other words, those cases that follow it, Noto versus United States and others, basically say that mere abstract calls for violence at some future date are protected speech. They are not prohibited. But what is prohibited, what violent speech is prohibited, is speech that has the specific purpose of inciting violence in the near future. In other words, I might say, come the revolution, you're the first kind of person I'm going to line up against a wall and shoot. That's protected political speech, and there's a case directly on point. But if I say, there he is, shoot him now, that is not. That's an incitement to engage in violence. Judge Wallace claimed that Donald Trump's speech, up to and including his speech on the ellipse on January 6th, was an incitement to violence, that the crowd understood it as such, and the crowd reacted in response and did therefore engage in violence. She also did something else that I thought was highly controversial. She accepted as reliable the House January 6th committee report on what happened on January 6th. And that's a report that laid blame at Donald Trump's feet and basically concluded what the government was never able to prove in any of the criminal trials that I've seen. And that is that there was a direct nexus or connection between Donald Trump and groups on the ground on January 6th that engaged in violence. I'm referring in particular to the Proud Boys. As regular listeners know, I defended Joe Biggs of the Proud Boys in a 5.5-month-long trial in Washington, D.C. earlier this year. I almost said earlier this week. It only feels like yesterday. In which the government persuaded a jury that the Proud Boys had a plan to engage in violence that day. Of course, on the government's rendering of events, plan could mean anything up to and including instantaneously agreeing when the peace circle breach of the barricades first took place. And the peace circle I'm referring to is an area near the Capitol where protesters first crossed a prohibited line. So accepting the J6 committee's report that this was a planned event, that Donald Trump planned it, she reached the conclusion that Trump specifically intended to do so, that he engaged in insurrection, and therefore Section 3 of the 14th Amendment arguably could apply to him. But she then goes on to ask whether Trump is an officer.
Well, yeah. So here we go. Quick, I guess reference back to a previous stream when you remember, Norm, when I found the original petition that was brought forth in this case and was scrolling through just volumes of, well, I guess just the table of contents and how specific and just far-reaching these allegations were, and the various means and mechanisms by which the petitioners were attempting to find some way to shoehorn shoehorn Trump into these various things. And so part of me believes that Judge Sarah B. Wallace, based on that, this order had to deal with far more than she should have had to deal with. But that also says to me that perhaps she felt obligated to do that rather than legally required, right? She felt almost like emotionally obligated to do that, or in some way she was thinking about the press that would flow from all of this if she simply ignored these things, Norm, that I think you and I would agree that she should have simply ignored, right? Especially given the conclusion that she came to. But on here, right, she asked the question, did President Trump engage in an insurrection? And she does find that Trump engaged in an insurrection on the facts as presented through this case, right? So she does find that Trump himself engaged in an insurrection. So make no mistake about that. And she puts, this is the statute that we're talking about, Section 3 of the 14th Amendment. But again, we're going to get to where he is eligible. But this judge, Judge Sarah B. Wallace, district court judge in Colorado, found that Donald J. Trump engaged in an insurrection on January 6th, 2021.
The 103 pages of the opinion, about 85 of the pages build that case. And she's emphatic about it. There's no question in her mind. The president of the United States engaged in insurrection. He incited others, the crowd and others, to engage in violence against the execution of the laws of the United States, to wit, the certification of electoral votes on January 6, 2023. Interesting asides, she reports a little known or little reported fact, and that is that Trump vetoed Alex Jones and Ali Alexander's appearance on the ellipse with him on January 6th at the urging of White House aides and staffers who regarded the men, quote unquote, as wackos, and he didn't want them on the stage. They were present in the vicinity, but not on the stage with him. But when the rubber meets the road, however, she engages in a kind of a specious and hyper-technical reading of Section 3 of the 14th Amendment, the pedantic reading that guarantees this case will go to the United States Supreme Court eventually. She concludes that Section 3 did not intend to include the president and vice president as officers of the United States. And she does so by saying, in part, an earlier version of the amendment included president and vice president. It excluded it in the one that was passed. That exclusion was intentional. Because they were excluded, they are not included. Because the language is somewhat ambiguous, only lesser officers are included. That's a counterintuitive reading of the act that I don't think will withstand scrutiny by higher courts. And so this is we had a comment from Freedom Lover. I don't care. I honestly don't care what Sarah B. Wallace says. Freedom Lover, neither do I. I wouldn't know her if she bit me. I'd get to know her, I suppose, in court. But I do care about what judges say when interpreting the law. And when we get a case of this sort reaching a controversial conclusion based on tenuous reasoning, it's a guarantee that other courts will see it otherwise. And when there's a disagreement about a matter this fundamental, it's a one-way ticket to the Supreme Court. So you see in paragraph 304, the court holds that is, this is a binding conclusion, that it is unpersuaded that the drafters intended to include the highest officer in the country in the catch-all phrase office under the United States. That I can't tell if that's a little bit of medievalism creeping into the law. Under medieval law, the prince was the law, and therefore was immune from its reach, because as the maker of the law, he couldn't bind himself. And sovereign immunity is a residual holdover from medieval law in the United States. I just don't read 14th Amendment Section 3 the way she does.
Well,
I
yeah,
think
especially considering subsequent to the court holding that it didn't agree that the drafters would have intended to prevent someone from being denied eligibility for running for president. But look at 305 there. Next, the court addresses whether Trump previously took an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state. Because President Trump was never a congressman, state legislator, or state officer, Section 3 applies only if he was an officer of the United States.
Yeah, I mean, yeah, that's sort of gibberish. And I think she's going to get her knuckles wrapped one way or another. So keep an eye on this case. A little bit of something for everybody there. The bottom line is he'll be on the ballot in Colorado, at least for now. I expect her decision will be appealed. I expect this case will find its way before the United States Supreme Court, probably in January or February, early enough to make a difference in next year's election.
Last thing here. I know that we're trying to move on, but my question is principally, was Trump not impeached for his acts up until January 6th, or no? Am I wrong about that?
Yeah, yes.
Okay. So what about these petitioners, and what about this court gives them jurisdiction to even decide? And I mean, in this order, this judge has concluded that Trump indulged in insurrection, that he is guilty or responsible for engaging in an insurrection within the meaning of the Constitution. What gives this court jurisdiction over that issue?
Why wouldn't it have it? Are you going to say that there's some sort of double jeopardy clause that extends from impeachment to a court's consideration of the issue?
Yes,
no court has ruled that.
I guess as to the rest of the country, right? I mean, if this is a national issue here, that there is a court taking up this issue, and now in an order, there is a court duly appointed and or elected based on whatever her history is, that is taken notice of all of what was concluded in the original petition from the petitioners, and come to a legal conclusion that Trump engaged in insurrection.
I mean, that's among the issues that has to be resolved in the 14th Amendment Section 3 context. Is, what sort of process or what sort of fact finding is involved? Is it a jury question? Is it a legal question? I mean, what we have now is a trial, the results of a trial. There was a court trial. She heard from, it seems like, a dozen or so witnesses over 5 days. And her conclusion was, based on the evidence that she received as competent and the credibility determinations she reached about the witnesses, she concluded that Donald Trump deliberately, with specific intent, the highest culpable mental state or in the law, with specific intent, incited others to engage in violence. They did act violently, and therefore he engaged in violence, or an insurrection. I mean, that's what courts do. Courts find facts. And so, I mean, unless you want to say that somehow the impeachment proceedings had a preclusive effect on what can go on in a courtroom, I don't see how it can be otherwise. And, the courthouse doors are open to anybody to bring any case or controversy. And the 14th Amendment, Section 3, arguably creates that right. Now, what we're going to have to develop are standards and a body of law that determine how to advance those claims. Sarah Wallace's decision is the most ambitious of them to date, and it bears watching.
Well, and I think that maybe the nice tie-in here is this story, because the petition relies in large part on the January 6th subcommittee for. And so
this, and I report on this development with a heavy heart. Apparently there are 44,000 hours of video surveillance gathered and held by the United States government about events in Washington, D.C. at the Capitol on January 6th. And they've not yet been made public. Speaker McCarthy promised to do so, hadn't. Laura Loomer and others called him out. Mike Johnson now says he's gonna or has released the remaining footage. And the result is going to be what exactly? Based on what I saw this weekend, it's going to be pure chaos. Because what I see people doing is picking selected pieces of the video and using that as a prism through which to view the entire event, and then advancing their own individual idiosyncratic narratives to say, see, this piece of video proves what I was trying to say all along. So you've got a group of people, protesters, peacefully marching down a protest while a hallway while officers watch them. This proves that the entire event was peaceful, and therefore my Uncle Joe couldn't have been convicted for engaging in violence with a cop. That's the tip. The tat will be somebody taking a piece of video showing violence against a cop, saying the whole thing was violent. Here's what I'm asking for. I'm asking for Elon Musk or somebody with deep pockets and access to artificial intelligence to download all 44,000 hours of these videos so that we, with the aid of machine learning, can interrogate it and come up with objective standards for evaluating what took place on the ground that day. I know a little bit about the events of January 6th, but just a very little bit. The little bit I know comes as a result of spending 6 months or 5.5 months in a courtroom with Joe Biggs and the Proud Boys while we watched the government present its methodical case to prove that they planned the events, the violence that occurred. I don't think the government did. We'll take that up on appeal.
You told me over the weekend, you said this. You said it would take a person more than 10 years to view the entirety of the 44,000 hours of video surveillance. If that's all that one person did for 12 hours every day for that 10-year span.
Yep. And, a lot of them will be irrelevant. There'll be scenes of the parking lot and so forth. But I think that, we're just not, it's just not, I feel very much as like I did when I first began to read the literature on the assassination of John F. Kennedy. Everybody and their brother had a theory about who did it, and scores of books have been written about the topic, each advancing idiosyncratic theories for which there is some support in a partially developed record. But the fact of the matter is, something happened in Washington on January 6th, and there are multiple claims of who was responsible. Many people on the right want to say it was a government setup, that the government permitted it, the government inspired it. The government caused it. The government did so because it wanted to cover up other things, including a stolen election in November of 2020. I just can't go that far because I'm not aware of evidence that supports that. And then I get wildly attacked as I was on social media because, somehow I'm a lackey or whatnot. Many things can be true at the same time. It may be the case that I don't doubt for a moment. In fact, I know it to be true that there were government agents embedded with the protesters. I'm not sure that means the government caused the entire event. I know that there were some people there that were intent on violence. I'm not sure that means that violence was planned. I know that there were many people there who just happened to be there and got caught up in the events. I don't know that they were used by those who planned violence. I don't know that they were used by the government. I think it was a confusing event, and that as many people as were present on the ground on January 6th, there are that many truths about the states of mind that obtained that day. But before we reach larger and broader political conclusions about responsibility for that event, we need to have a dispassionate, even-handed, and fair evaluation of the 44,000 hours of tape. And I don't know how to do that myself. I don't have time. Even if I stopped practicing law and did nothing but made J6 my full-time preoccupation. And listen, deep pockets out there, if somebody wants to retire me from doing it, I'll happily spend the time. I am that intrigued by what happened that day. But even if one person can do that, it's going to take a lot of time. And what's happening is battle lines are being drawn. And I'll confess, I'm in the fight. I am on the side of those accused of J6. I am so violence on J6. I am so outraged and disgusted by the conduct of the Justice Department in its prosecution of J6 protesters that I would vote for this guy as president, Mr. Pumpkinhead, if it meant getting rid of Merrick Garland and cleaning house of the knuckleheads in the Justice Department right now. Their prosecutions are dead wrong. The theories they advance are convenient political half-truths that they are using to criminalize dissent in this country. And I will not spare any effort to derail their efforts on any defendant accused on January 6th. Having said that, I'm still not sure that I can go so far as to say the government caused this. I think it was a complicated event that reflects on the legitimacy crisis in the United States and our competing narratives about the common good. And what I fear is that battle lines are being drawn in J6. It's now becoming a permanent thing in American politics, much like the JFK assassination was. And what we're going to do now is we're going to spend 5, 10, 15, 20 years arguing about its meaning, using isolated pieces of data to prove the day's talking point in a way that obscures larger truths. But having said that, I find myself on the side of J6 defendants in many uneasy alliances with people. Sometimes these people are advancing narratives I don't think there's responsible evidence to support. But I'd rather side with them and the individuals accused than the government and the accusers who've made up out of whole cloth a narrative that somehow the Proud Boys caused it all, that they had a plan to engage in violence that day. It just didn't happen. I sat there. I watched the evidence.
And to that end, what Don says here, it's not what happened, but what the DOJ did that is the issue. That is
that's one of the issues, Don. I agree. I agree.
And also to just on your point about, you won't go so far as to say that the government caused this, because that would assume that there was some sort of uniform alignment or some sort of monolithic view of how best to do these, how best to transact on January 6th within the government offices. Because remember, we have the federal government there, but we also have the mayor of DC, right? Muriel Bowser. We have the National Guard.
That's Bowser speaking.
We have all sorts of different competing interests with respect. If we're looking at the power vector, the political power vector, there are all sorts of people that are looking there to pull out some sort of leverage from the handling or the mishandling of this event. So it's not clear to me that even within the halls of government that there's any sort of uniformity and therefore any sort of uniformity of blame to follow, right? But I think that most people would agree that there isn't anything benevolent being done within those halls of government, right?
No, I think that's true. And I think the political gains to be made on both the left and right out of January 6th are a national tragedy. The best thing that this country could do right now would be to demand a cessation or ceasing or stopping of any further prosecutions on January 6th. Let these guys out of jail and move on. I've said this here before. I'll say it again. 3 years after the Civil War, we had repatriated almost every rebel. That was a fight that cost the lives of 600,000 Americans. How is it possible? How is it possible that 3 years after an afternoon's riot, we're still prosecuting people and demanding they be locked up and designated as terrorists for an afternoon's riot? It's just unseemly, and it suggests that there's something rotten going on in this country. And of course, I think the primary instigator of that rottenness is Merrick Garland and the knuckleheads who are running the Justice Department right now. They have got to go. This has gone on way too far. And unfortunately, the 44,000 bottles of beer on the wall, that is the 44,000 hours of tapes that Speaker Johnson just released, are just going to fan these flames, and things are going to get worse. And so if somebody has access to Elon Musk or somebody has access to somebody with deep pockets, let's get these tapes into a machine learning device. Let's begin to interrogate the tapes.
It's called Grok. So I think that what we're going to do with the LawPod Daily account, and I may do it with my personal Norm, you can decide what to do with yours, because I'm not even personally verified on X yet. But
you don't exist at all. I mean, yeah.
And this is what I'm talking about is Grok. This was announced earlier in November. This is X's AI model. Right. So this would be the equivalent of Chat GPT, right? Or the counterpart to Chat GPT. So what you're asking for, Norm, to me is being built on X as a platform, right? A competing generative artificial intelligence engine in which these videos could be placed and analyzed. Perhaps, I don't know. But it is something that will be coming to the X platform. And as a parallel competitor to what we know right now produces and yields results with a real liberal bias in OpenAI.
Here's the problem. I mean, I understand AI's capabilities and its potential to transform the world, but I don't understand how to interact meaningfully with it. So, for example, putting 44,000 hours worth of video into a machine learning device will give the machine the ability to conduct rapid analyses of things, but what patterns it selects or what patterns that emerge from it, I'm not sure at what level the interrogator of the machine, that is the human, dictates that. So the things I want to know are, just how many federal agents were involved, just what level of governmental coordination in reaction on the ground took place. I want to know what individuals were there. I want to know what communications they had between one another. And I'm speaking not simply of governmental individuals, but of private individuals. I want to know, for example, more about Ray Epps, the infamous Ray Epps. And so, whether AI can help with that, I've got to believe it can do more than we can, because before I spend the next 5 or 10 years of my life responding to each email and phone call I get from somebody who just watched a snippet of one of the 44,000 hours of tapes and now has the meaning to it all, I'm craving a broader context. So let's talk about how to get this on Grok, Mike, and let's get it done.
Quickly moving to the story that we teased on Friday. And in particular, Norm, I don't know, it's right here at 8:30, so I know typically on Mondays we don't want to go too far into past that half hour. But what is involuntary manslaughter?
Well, so the model penal code is something that is drafted by the American Law Institute, and it's what lawyers study in law school to get a sense of how the concepts in criminal law hang together. Some states are heavily influenced by the model penal code and others aren't. I'm not an expert in California law, so I don't want to talk about that, but I want to talk about what typically is involved in making an assessment of manslaughter in general. So manslaughter is in the class of offenses known as a homicide, that is the taking of a human life. And there are degrees of culpability. The most culpable form of manslaughter is what we call in Connecticut murder, what some jurisdictions call murder in the first degree. That is specifically intending, having in your mind the conscious objective to kill someone and then killing them. Another form of homicide is manslaughter, where you may have the specific intent, the conscious objective to cause someone serious physical injury. Serious physical injury means the impairment of some organ or bodily part, significant impairment, serious impairment of it, but they cause death. So, I mean to break your nose, or I mean to break your arm, but you die as a result. That would be a form of manslaughter. I still had the specific intent to cause you serious physical harm. Involuntary manslaughter is a less culpable form of manslaughter. It's where you engage in reckless or negligent conduct, not intending to cause someone death or serious physical injury, but they die nonetheless. And so in the case of the elderly man with a megaphone, the claim is that he was protesting in favor of Israel, and a protester approached him, a college professor, a 50-year-old, I think, information science professor from somewhere in California, go figure, approaches with a megaphone in hand, and there's a confrontation, and the elderly man is struck in the head or the face with the megaphone, falls and dies. And therefore, the defendant's conduct with the megaphone caused his death, but he neither intended to cause the death nor intended to cause physical injury. But death was the result, and therefore it's a homicide. What's at stake in the gradations of these various forms of homicide are penal consequences. So, for example, in Connecticut, a person accused of murder and convicted of murder can expect to do a minimum of 25 years in prison, a maximum of 60. There's something called murder. We don't have a death penalty in Connecticut. There's something called murder with special circumstances, and killing a child or killing a woman in the course of a rape. That's a mandatory life term, no matter how long you live. A lesser form of homicide would be manslaughter with a firearm. That's a mandatory minimum of 5 years, a maximum of 40 years. Without a firearm, manslaughter carries a minimum, I think, of 1 or 2 years, a maximum of 20. And then there's criminally negligent homicide, which carries a maximum of 1 year. It's a misdemeanor. So in each case, a defendant is accused of unlawfully causing the death of another, but the person's mental state, that is what informed their action, whether it be the conscious desire to kill, to injure, or simply to engage in reckless or negligent conduct that resulted in death, that drives the penal consequences.
So we're talking about something similar to getting behind the wheel of a car, intoxicated, and then getting in a wreck and somebody dying as a result of that. right?
Yeah, I mean so there are that conduct would be captured within that framework that we've discussed. Yes.
Right. And so I guess my more narrow question is what is not being charged here, right? And because I'm thinking about certain things as, okay, if the gentleman was struck in the head with a hammer and not a megaphone, we would be talking about something else. Yes.
Well, I don't know a whole lot about the circumstances, but a hammer as an instrument that you use to apply concentrated force on objects, a nail or a person's head, depending on the circumstances. A megaphone is a device that's used to amplify your voice. Now, as I understand the event in California, the defendant was amplifying his voice at an emotional protest when two individuals interacted. Did he choose, the defendant, to use that megaphone as a weapon? Or in other words, did he intend to cause harm with it? Or did the manner in which he used it result in harm? And was that use informed by recklessness or negligence? Those are two mental states
and
that are
also
significant.
Determination by the triers of fact, right?
Right. So, I don't know what the appropriate level of charges are here.
Yeah, all I'm saying is that a megaphone is not typically seen as something that could do damage in the way that a hammer would, right? Just drawing a distinction between reckless conduct with an object in one's hand, right? A megaphone is not a hammer, for example, right?
Well, let's put it this way. Your home improvement guy ends up at your house today to put a new roof on, and he's got a megaphone but not a hammer. I'm thinking you hired the wrong guy.
I'm going to yell for other people to come help. Anyway, you there, Norm?
I am.
Okay, you froze just there for a second. All right, well, look, we've already gone over time. I just wanted to quickly hit that. We will track this case. I think many people were, I guess, concerned that involuntary manslaughter was not charging enough. Certainly within the context of a modern America in which criminal charges are frequently overcharged and then pled down, is something within the context of the Israel-Palestine conflict, what we're seeing on American soil, the emotions that are rising in these sorts of in-person interactions. Does involuntary manslaughter capture the essence of really what we're talking about here? And is it a decision by a prosecutor to stay almost politically neutral on the topic?
Well, I mean, that's a great question. I mean, had the decedent, the person who died, been black, and the wielder of the microphone, a member of the Proud Boys, one gets the impression that they would have charged far more than involuntary manslaughter as leverage to extort a plea. Did they charge the bottom of the barrel here because of the politics of the situation? Possibly. Unfortunately, prosecutorial charging decisions are largely unreviewable, and they have discretion to charge as they think appropriate. As a criminal defense lawyer, I am a frequent critic of overcharging as a way to extort pleas, so I was not troubled by charging low here. I think prosecutors have a responsibility to try to get it right, whatever that means, to do justice, whatever that means, and I don't think overcharging serves that purpose.
I agree. One thing I want, and we'll end on that substantively, we'll end on that. One thing I think that you and I agreed on over the weekend, Norm, is that we're going to stream every day this week. Yeah?
We are, and we're going to have an announcement about Owen Schroyer on Wednesday morning at 8 a.m. So come back to get the latest on Owen Schroyer Wednesday morning, 8 a.m.
So we will be here today. Obviously, we've already been here tomorrow, Wednesday, Thursday, Thanksgiving, Friday, Black Friday. We will be here every day, 8 a.m. as normal, so you know where to find us. So early Thanksgiving morning when everybody else is running around the house, you could squirrel away in a room somewhere and get your daily dose of Law and Legitimacy.
Get a moment's sanity.
And as Norm said, on Wednesday, we will have an announcement here exclusive to Law and Legitimacy regarding Owen Schroyer and his confinement down there in Louisiana. Is that correct, Norm? Louisiana?
Yes, it is. Louisiana. In fact, last night I got word that House Speaker Representative Mike Johnson's office is making an effort to go and see Owen. I know Marjorie Taylor Greene and Matt Gaetz were reportedly en route last week. I don't know if they ever arrived. But we will have an update on that and some other developments in Owen's case on Wednesday morning.
Awesome. Well, Norm, thank you. Glad to be back in the saddle for another week. If you are still with us, make sure you're following us on X at LawPod Daily. We stream there live every day, as well as Rumble, which I understand has gotten some sort of app upgrade or improvement. Now, Norm, I understand it doesn't take 3 or 4 minutes for the live notification to go out. It only takes 1 minute. So I made the joke earlier that we've got like a battered spouse syndrome going on. Like, oh, I can only get beat once a day now. Anyway, if you're unhappy with the timing for this, maybe just join early over on X or on YouTube if Rumble isn't meeting your needs. But I will say that the chat feature on Rumble, that is where most of our interaction comes from. So I'm hoping that Rumble #1 gets a static stream key figured out. You've been cooking on that for a while. It's Thanksgiving week. Why don't you finish that turkey, please? And hopefully we can get the delay ironed out on that side as well. But anyway, if you don't find us here on the video streams, we're on Apple Podcasts, Google, Spotify, Overcast, wherever you find premium podcast. Norm, I will see you tomorrow morning at 8 a.m., my man.
That you will. Go Blue. Not too much longer till the game.
See you later, everybody.